The President, please be seated. The chamber is now in session. This is the second day of the proceedings in the initial hearing. It is mainly to deal with the preliminary objections and oral arguments on the principle of ne bis in idem, which the parties, including the defense team of Mr. Ieng Sary, presented yesterday, as well as the response from the prosecution. Also, the lead co-lawyers team responded to the submissions by the defense team yesterday. It is now appropriate time for the defense team of Mr. Ieng Sary to make a reply if they wish to do so to those responses.
Mr. President, good morning. I see Mr. Nuncia has his hand up.
The President, Mr. Nuncia, you may speak. Nuncia, my name is Nuncia. My respect to your honors, Mr. President, and all my compatriot citizens. Since there is no agenda to be discussed in relation to my case, and only the discussion focuses on Ieng Sary's defense team, I will walk out and return to my detention facility. Only in the cases where my cases are to be discussed, I shall return to actively participate in the proceeding. The President, we have heard the request by Mr. Nuncia of his objection to follow the proceeding, and this is the right of the accused, and the chamber decided to grant his suggestion. He can now remove himself from the courtroom and return to the detention facility. Security guards, you are instructed to bring him back to the detention facility. Mr. Canavas, you may take the floor, says the President.
Good morning, Mr. President. Good morning, Your Honors. Good morning to everyone in and around the courtroom. I do indeed have a reply to the arguments that were made yesterday by the prosecution and by the civil parties. I'm first going to address some of the remarks that were made by the civil parties, and then I'll get to the more substantive arguments that were made by the prosecution. What we heard yesterday from the civil parties effectively was a variation of an opening statement and a closing argument. It is not proper advocacy when dealing with issues of law. I did not object yesterday. It wasn't because I didn't think of it. It was out of respect, given that it's the first day. However, I do submit that when dealing with legal issues, we should stick to the legal issues. And there will be a time when the civil parties can vent their anger towards the accused and proclaim how guilty they may be and how much they should suffer. But yesterday was not the time. Now, one of the points that was raised that was that they would be deprived of the full truth. The victims would be deprived of the full truth if, for instance, Your Honors were to grant this application. Well, first and foremost, the historical truth will never be found in this courtroom, or any courtroom for that matter, because courts are not designed for the historical truths. Also, because of the temporal jurisdiction of this particular tribunal, we're only dealing with issues dealing from 75 to 79, and perhaps, other than for contextual reasons, where we might be able to bring in evidence as to what may have happened in the 50s, 60s, 70s, 90s, and what have you in Cambodia, the whole picture, the whole truth will never be revealed. But be that as it may, that is not a reason for denying this application. It may be denied for other reasons, but not because the civil parties feel that the whole truth for the victims will not come out. This is not a valid consideration here today. Now, turning over to some of the submissions made by the prosecution. One is considering what the pretrial chamber found with respect to Article 12 of the Cambodian Court of Criminal Procedure. We submitted yesterday, as we had done in our pleadings, that the prosecution's point of view, as expressed yesterday, was incorrect. The pretrial chamber never considered the application of Article 7 of the Cambodian Court of Criminal Procedure alone, in and of itself, that is. And the impression that we received yesterday from the prosecution that this had been done. We submit it had not been done, and thus I think this trial chamber should pay close scrutiny and attention when examining the arguments and look at the application of Article 7 alone, and then the application of Article 12, and then perhaps how they interplay and how they interact. Yesterday we heard arguments, it was both from the prosecution and from the civil parties, concerning the charges in the 1979 trial, that the trial only had one charge, which was essentially genocide. Well, as the old adage goes, a rose by any other name is still a rose. When you look at exactly the charges, I don't wish to take up too much time. I have them printed out, but when you look at the charges, you see that it's not just genocide. In fact, when you go through it, you cannot come to any other conclusion other than it contains all of the charges which the closing order contains today. Now, during the preliminary motion practice that we engaged in, this issue did in fact come up. And we did in fact provide the pretrial chamber which I'm sure you must clearly know of it. We provided them with a chart where we actually analyzed all of the elements of the crimes to which Mr. Inksery was charged under the introductory submission with the 1979 charges. And that can be found in Inksery's submission pursuant to the decision on expedited request of co-lawyers for a reasonable extension of time to file challenges to jurisdictional issues. This was dated 7 April 2008, and affixed to this motion was Annex C. At the time, it was confidential because of we were referring to matters in the introductory submission. And in there, in Annex C, we did a comparative chart between the charges in the introductory submission and the 1979 charges. And we submit, Your Honors, that it may be useful. It may be of some guidance to the trial chamber in looking at this particular argument raised both by the prosecution and by the civil parties, that what the 1979 trial was only about genocide. We submit it covered everything to which Mr. Inksery faces here today. And the fact that it may have been characterized slightly differently, different terms may have been used, when you look at the actual underlying offenses, and that's what's important, substance over style, you'll see that they are the same. Now, then another argument that was raised and has been used is about the term internationalized, that the ECCC is an internationalized court. It is not a domestic court, and no one has dared use the word international, perhaps for political purposes. But the prosecution pointed out that this tribunal, that this trial chamber and the pretrial chamber, and I believe even the OCIJ, has come up with this term internationalized, and therefore it is internationalized. And of course, during the course of one of the arguments, the prosecution, and I'll get to that with respect to the ICC jurisprudence that they made reference to, indicated that the defense counsel provided no authority. No authority. Now, where is the authority that there is such a concept of internationalized? Where did that come from? Can someone point to me some authority that actually recognizes this concept? It came from, or it was coined, I should say, by the Special Court for Sierra Leone. They coined the phrase. This trial chamber then adopted it and said, well, it's internationalized. Now, in Sierra Leone, you have to look at that particular case for what it was. Sierra Leone wanted an international tribunal. They went to the Security Council and they wanted something modeled after the ICTY and the ICTR. The Security Council did not give them that. But the request was specific, and they came up with a hybrid court. That is vastly different than what occurred here, and I'll get to that. But my point is, if we're going to be talking about authority, simply because one court in some one distant place comes up with this phrase doesn't make it so. That's not authority in and of itself, because when you look behind that, you will see that there's no foundation. Now, I understand why it's necessary to call it internationalized. It's a convenient way to get around national law, national jurisprudence, when it's inconvenient. And obviously, it would be inconvenient in this instance, especially when we get to the next argument, which is the royal pardon and amnesty issue. But if indeed there is this concept of internationalized, which is what we're saying is it's international whenever we want it to be. If there is such a concept, then when the issue of corruption came up concerning the ECCC, why did the OCIJ, the PTC, and the trial chamber deny the request for the parties to see, the defense at least, who were making the request for the actual report on the corruption, based on the arguments which we were making that it affects and it poisons the investigative process and perhaps even this process itself? We were told that's a national issue. The national government asked for it, and only the national government can give authorization for that report to be turned over. That may be the case. But what is that indicative of? It's a national court. Let me give you another example. When my client goes to get medical treatment and he's in the hospital, I have absolutely no access to him. Zero. Why? Because the Ministry of Interior has posted security over there, and they've been instructed that no one, absolutely no one, including his counsel, can have access to him. Why is that? Because the detention center is run by the Ministry of Interior. That's why. And I point these as examples to show that this is a national court. It is not internationalized, and is certainly not international. Now, getting back to the ECCC as being a domestic court, you have to look at, for instance, how it was established. And I don't want to go into the entire history of it due to time. We have extensively covered that in many of our pleadings, but it was made very clear by the Prime Minister and the government that what they wanted was assistance, and they created the special chamber within the context of the Cambodian court system. And we do say, and we do submit, that it is a national court, national law, and national procedure should be applied with the exceptions provided in the establishment law. But in particular, when it comes to procedure, we have argued repeatedly that unless there is a gap, the criminal procedure of Cambodia should apply. With respect to Sierra Leone, I believe I've already addressed that. I don't want to belabor the point. The next point I wish to raise is concerning the ICCPR, the International Covenant for Civil and Political Rights. It was raised by, I believe it was the national co-prosecutor, and she mentioned that Cambodia only acceded to the ICCPR in 1992. But we submit that this is completely irrelevant for what we're dealing here today. Today, Cambodia is a party of the ICCPR, and Article 31 of the Cambodian Constitution requires that Cambodia respect international human rights instruments such as the ICCPR. Now, it doesn't say explicitly ICCPR, but we all understand what that means. And of course, the agreement in the establishment law explicitly have set out that the ICCPR applies to this tribunal, and if we look at it very closely, and I didn't hear the prosecution say anything about exceptions being found in the agreement or the establishment law. You won't see, for instance, however, concerning Article 14, there is this exception. There is none. The prosecution would have you believe that, yes, with respect to that particular article, that subsection of that article, an inconvenience to these proceedings does not apply. We submit the entire ICCPR applies. You cannot, as we say, cherry pick. Pick what you like, discard what you don't like for the sake of convenience. Now, let's talk about that trial, the 1979 trial itself. Was it perfect? Of course not. Would any of us want to be tried in that fashion Absolutely not. And I mentioned that to start with. But my point was, no one ever has come out and said publicly, either or during the negotiations at the UN Assembly, no one came out and said that the conviction itself and the judgment itself and the sentence itself was not valid and it could not be executed. No one. That shows that that judgment was valid. It also shows that at any point in time, had Mr. Inksheri been arrested, he would have been executed because that was considered a final judgment. During the Paris peace talks, nobody mentioned that. Thereafter, nobody mentioned that. It was for those very same reasons why in 1996, when the two prime ministers that were running the country and wanted to co-opt the Khmer Rouge soldiers that were associated with Mr. Inksheri, why they went to Mr. Inksheri and why this pardon was an absolute necessity. Because that sentence, although he would not have been given the death sentence, hung over his head. But who are the People's Revolutionary Tribunal? Because there was some indication that this was not a proper body because it had been established by the executive branch. And we all know, at least where the rule of law applies, and when you have true democratic democracy, that you have a separation of powers. And I think we agree on that point. But in 15 July 1979, the People's Revolutionary Tribunal was established by decree law.
The President Council, you are reminded that you have 15 minutes and your time is running out. We give you a few more minutes to finish it off.
Yes, Your Honor, but as I indicated yesterday, and I don't wish to debate the point, I accept your admonition or your warning. Yesterday, I did not use my entire time, and I'd indicated that I would not be using it so I could use it for the reply. But if that's not permitted, then I will move it along. The point that I'm making here, in this tribunal was set up by the People's Revolutionary Council of Kampuchea, where you had Heng Samrin as the head of state, Chea Sim as the Minister of Interior, and Hun Sen as Foreign Minister. And when you look at what this body was entitled to do, because this was a transitional period, it had the capacity of also establishing legislation. We saw that in Cambodia once again during the UNTAC period. And another very good example is what is happening in Bosnia and Herzegovina even today. You have the Office of the High Representative. It's a foreign body. It hasn't been elected, yet the High Representative has the capacity of drafting and passing laws, striking down laws that were adopted by the entities or even at the state level. And so this is not an uncommon practice in places where there are transitional authorities. And so that we submit that there was nothing wrong with the establishment of that particular tribunal, and the establishment of that tribunal was for the purpose of establishing guilt or to bring to justice those they believed were responsible for certain events. It wasn't for the purposes of evading justice. And we submit, Your Honors, since I'll wrap it up since I'm running out of time, that this particular principle is to ensure, to combat impunity in a sense. When it was brought out for the first time at the ICTY explicitly, the purpose of this particular principle, ne bis in idem, was to ensure that Bosnia, Croatia, Serbia did not try individuals, summarily acquit them, and therefore prevent them from being properly tried. To date, neither in the former Yugoslavia, any of those states, or in Rwanda, am I aware of a single case where there has been poor prosecution of an individual, and for the ICTY or the ICTR to request that case to come back to it so the individual could be properly tried. Specifically at the ICTR in Rwanda, what has happened there, where many individuals have been summarily tried and summarily executed, it was never invoked. And my point is, this principle, by and large, was set up to ensure that you would not have bogus trials, false trials, where acquittals were handed out in order to promote impunity. And with that, Your Honors, I believe I have nothing further. I appreciate the extra moments provided to me. And if I did test the patience of Your Honors yesterday, I truly apologize. I will try to mend my ways. And yesterday, Your Honors, as I've indicated, when I'm called, I stand up. It wasn't, I meant no disrespect, Your Honor, and unless I'm given permission, I don't feel free to sit down. Thank you very much for your attention.
The President, thank you, Counsel. We shall now move on to another topic of the agenda. That is the oral argument on statutory limitations in relation to amnesty/pardon. We shall hear the oral argument by the defense team on the effect of amnesty pardon given by the King to Mr. Ieng Sary at the request of the government at the time. This preliminary objection has been raised by the Ieng Sary's defense. The Ieng Sary defense has been allocated 1 hour for the presentation of legal arguments in relation to this preliminary objection. The co-prosecutors then have 45 minutes in response, and the civil party lead co-lawyers 30 minutes. The Ieng Sary defense then have 15 minutes to reply. Concerning the Ieng Sary's defense request for clarification of the trial chamber's agenda for the initial hearing regarding the royal pardon and amnesty, the chamber notes that it has already indicated that it is presently most interested in the question of whether, as a matter of law, an amnesty/pardon can extend to crimes of the gravity of those for which the accused Ieng Sary is charged. It will consider whether it is necessary to call the witnesses sought by the Ieng Sary defense in support of this preliminary objection at a later stage. The chamber reminds the parties that it is familiar with all written pleadings filed to date and urges them not to merely repeat these in oral argument. I would like now to give the floor to Ieng Sary's defense to make their presentation of the preliminary objections. Ang Odom. Good morning, Mr. President. Good morning, Your Honors. Before I commence my presentation on the royal pardon and amnesty, I'd like to make a request that in order not to interrupt the flow of the oral arguments, the request is that It is for my client, Mr. Ieng Sary, to return to the room downstairs when he needs to go while we make or present our oral argument without interrupting the proceeding. If Your Honor permits, then my client, Mr. Ieng Sary, shall leave at any time that he needs to. If the chamber does not allow, then when he needs to, then I would seek permission from the chamber, from the bench. And I'd like to seek your permission on that, Mr. President. The President, first, can you clarify your request? You need to show us the reasons to support every request that you would like to raise before the chamber, so that we can use it as the ground for our decision whether to allow or to reject it. Secondly, what you said, according to what you just did, cannot be allowed. You need to clearly state your suggestion when and how with proper reason, then we shall decide. And when you say the word at any time, and if any problem arises in relation to his health, then the chamber shall decide based on that particular circumstance. As you are aware, just then another accused, Mr. Nuon Chea, waived his right to participate by providing his reason as that the preliminary objections raised are not related to his case, and that he requests that the issues to deal with his case shall be considered. So with such proper reason, the chamber decided accordingly. Therefore, as a lawyer, you would need to clarify and make your statement clear. Counsel Al-Adam, thank you, Mr. President. My apology. I shall now continue with my presentation in relation to the royal pardon and amnesty. In relation to the royal pardon and amnesty, we have 3 submissions to make before the trial chamber. First, the ECCC only has competence to determine the scope and not the validity of the royal pardon and amnesty. Second, even if the trial chamber does decide to determine the validity of the royal pardon and amnesty, it is valid at the ECCC. Third, the scope of the royal pardons and amnesty prevents the prosecution of Mr. Ieng Sary at the ECCC. However, as it is important to understand the issues surrounding the royal amnesty and pardon, a brief background is necessary. Background. In August 1979, Mr. Ieng Sary was tried and convicted in absentia for having committed genocide. The judgment condemned Mr. Ieng Sary to death and confiscated all of his property. On 15 July 1994, the Cambodian National Assembly promulgated the law on the outlawing the Democratic Campuchia Group, which is referred to as the 1994 law. The 1994 law declared inter alia that the Democratic Campuchia Group and its armed forces were outlaws and that membership in the group was illegal. The 1994 law came about as a comprehensive attempt to end the war and begin the process of national reconciliation. In September 1996, Mr. Ieng Sary and the Royal Government of Cambodia began negotiations for Mr. Ieng Sary's reintegration. Mr. Ieng Sary stated that he would not reintegrate with the Royal Government of Cambodia unless he received an amnesty from any future prosecutions for any alleged acts. This was a non-negotiable condition for his reintegration.
Your Honours, further to the negotiations for Mr. Ieng Sary's reintegration, the then co-prime ministers Hun Sen and Prince Norodom Ranariddh approached the King Norodom Sihanouk, the then king, requesting a pardon and amnesty be granted to Mr. Ieng Sary. The co-prime ministers said that Mr. Ieng Sary's actions were very valuable for peace and national reconciliation. The former king agreed to grant a royal pardon and amnesty as long as 2/3 of the National Assembly supported it. The National Assembly supported the royal pardon and amnesty as proposed by the two co-prime ministers. At that time, co-prime minister Hun Sen stated that it had been easy to collect the signatures from members of the parliament in the 120-member National Assembly. Further, the public also supported the royal amnesty and pardon. Your Honours, next, I would like to touch upon the issue of the competence of the ECCC. Moving to our first submission, we respectfully submit that the trial chamber does not have jurisdiction to consider the validity of the royal pardon and amnesty. The validity of laws promulgated by the king may be reviewed by the Constitutional Council for its constitutionality. The ECCC is not a constitutional court. The agreement and the establishment law authorize the ECCC to determine the scope of the amnesty, but do not give explicit jurisdiction to the ECCC to determine its validity. Your Honours, now I would like to move on to submit that the royal pardon and amnesty is valid at the ECCC. Moving to our second submission, I will address the validity of the royal pardon and amnesty. The royal pardon and amnesty was validly granted in accordance with the Constitution. Article 27 of the Constitution places no limits on the authority of the king to grant amnesties or pardons, nor does it place any limits on the scope of any amnesty or pardon granted. It simply states, quote unquote, the king shall have the right to grant partial or complete amnesty. Article 90 and Article 90 new of the Constitution states that, quote unquote, the National Assembly shall adopt the law on the general amnesty. The king granted the amnesty, and the royal pardon and amnesty was approved by the National Assembly by 2/3 of its members. As the ECCC must follow Cambodian law, it must find the royal pardon and amnesty to be validly applicable at the ECCC. Now I move on to the scope of the royal pardon and amnesty, which prevents the prosecution of Mr. Ieng Sary at the ECCC. Your Honors, I will finally address the scope of the royal pardon and amnesty. The scope of the royal pardon and amnesty prevents Mr. Ieng Sari's prosecution at the ECCC. Mr. Ieng Sari negotiated that he would only reintegrate if he received an amnesty from any future prosecutions for any alleged acts. This was a non-negotiable condition. I do not think the trial chamber needs reminding that without Mr. Ieng Sari's reintegration, the Cambodian civil war would have continued at full pace and would possibly be still going on today. Resulting in countless more casualties. The scope of the 1994 law covers all acts being tried at the ECCC, and the scope of the pardon and amnesty prevents Mr. Ieng Sari from being sentenced for the acts he is being tried for at the ECCC. This concludes my oral submissions, and my international co-lawyer, Mr. Kanavas, will now address Your Honors on these issues. I thank you, Mr. President and judges, for your courtesy and attention.
May the be.
Mr. President, thank you, Counsel Ang Adam. Now, Counsel Kanavas, you may take the floor.
Good morning again, Mr. President and Your Honors. I'll try not to be repetitive. There may be some overlap, only for contextual purposes. As I understand it today, we were asked to, as you've indicated, Mr. President, to address certain questions that were of particular importance to the trial chamber, since these issues, I can say with a certain degree of certitude, that were briefed by all parties extensively. One of the issues has to do with the translation matter. What exactly, which translation prevails, and what exactly was actually offered? And that's one of the questions. The other question is whether the pardon and amnesty granted to Mr. Ieng Sari are in conformity with the Constitution, in particular Article 27 and 90 new of the Constitution, and of course to address the pretrial chamber's decision on these matters. First, let me address one preliminary matter that came up only last Friday, and this was an issue. This was a document that was presented to us by the prosecution, and we wish to thank them for bringing it to our attention and to the court's attention. This was the decree number 28, Council of State, People's Republic of Cambodia, and there are certain aspects of this document were highlighted, First and foremost, when we look at this, it does appear to come from 1988, 20 June 1988. It comes from a period where you had the People's Republic of Cambodia. It predates UNTAC. It predates the present Kingdom of Cambodia. And of course, it predates the 1993 Constitution. So to the extent that this particular decree does not provide for any amnesties, that issue is irrelevant. I presume, if I'm reading the tea leaves, as they would say, that the prosecution is presented this document to the parties in order to advance its argument as far as what is the controlling word in Khmer with respect to amnesties or pardon. And as I will discuss later on, this has little value, if any, for the particular discussion. So I bring that to your attention for your consideration. I'm sure we're going to hear more from the prosecution, and I'll have an opportunity to reply. Now, the second issue I wish to discuss is something that deals with context, which puts the matter of the royal decree, the royal pardon and amnesty into perspective. We heard a little bit as to what it was, but why was it given? And what support did it actually receive? And it would appear from publications and from the Prime Minister Hun Sen's own account that this royal pardon and amnesty brought not only closure to the conflict, but also that it was overwhelmingly supported by the people of Cambodia, that it was necessary and that it was appropriate. And I think that is something that is of significance, because it doesn't appear that the amnesty was given for purposes of impunity, but rather it was given for the very same reason that amnesties are normally given. And for instance, if I may use something that's very topical today, or perhaps it would have been more topical yesterday or the day before, President Sarkozy of France, and France is a permanent member of the Security Council, as we all know, with respect to Gaddafi, had indicated, according to the BBC, and this is prior to yesterday, and when we know that he was, Mr. Gaddafi was indicted, that all options are available. All options. And from that, one could determine, for Gaddafi that is, and that can only mean that that would include also amnesty, the ability for Gaddafi to leave Libya, not be prosecuted, and in order to stop the ongoing bloodshed. That's the purpose of an amnesty. It's been around ever since mankind. It may be distasteful at times, but that's the purpose it serves. So, I'll wait until my colleague finishes. Okay, now, if I go on to the, Mr. Angudam already indicated the validity of it, of the amnesty itself. Clearly, the king is allowed by the Constitution to provide an amnesty, and the scope of the amnesty as well. But nonetheless, we were asked also to talk a little bit about whether this is in conformity with the Constitution. And this issue is very relevant for the purposes here, because there seems to be, there are arguments that the amnesty itself violates certain international norms, and therefore it is impossible for the king to have granted an amnesty of this scope. Also, that Cambodia had signed on to certain international instruments which effectively would prevent Cambodia or prevent the king from granting such amnesties. Our position has been, and it has been rather consistent, that this particular amnesty, which is very narrow in scope, narrow in a sense that it only deals with one particular individual, and therefore the argument that was made by the civil parties that the truth will not come out, that the victims will be cheated, and in this particular instance, we're dealing with one individual. It does not prevent this court from trying any of the other leaders. Now, this is rather important because when you compare this amnesty with the one that was given in Sierra Leone, when the United Nations signed on to it as a moral guarantor, and I'll talk about the postscript that they put on after the signing of it. But when you look at that particular amnesty, Your Honors, that was a blanket amnesty for everyone. No one was going to be prosecuted. In this particular instance, we're only speaking about Mr. Ieng Sary. And the reason I mentioned about the impact that this amnesty had on the country itself, you have to weigh that. It was a quid pro quo. You put your arms down, you come in, you allow the troops to integrate with the national troops, which indeed is what they did. And in exchange, there is a benefit. The benefit is you will get pardoned and you will get an amnesty. And we'll talk about a little bit more of the specifics. Now, eventually we all know what happened in Sierra Leone. That amnesty didn't hold up. It didn't hold up because one of the parties that signed on to it reneged. They backed off. Amnesty was provided on condition that the fighting would stop. The fighting continued after the signing of the amnesty, and so the government was perfectly within its rights to say, you have violated one of the conditions, and based on that, they went then to the United Nations and asked for the establishment of a court. In this instance, Mr. Ieng Sary has abided by all of the conditions of the amnesty, and the amnesty itself, as I've indicated, brought fruit, the very fruit that it was intended to bring. Peace to Cambodia, because after that, the rest either put down their arms or just gave up. So we maintain that, number one, national jurisdictions have the capacity to grant amnesties. States can grant amnesties even when we're talking about crimes such as the ones that we find in this particular indictment. I'm unaware of, and perhaps I'm wrong, but I am unaware of any jurisprudence which mandates that there's actual prosecution for crimes of the sorts that we have in our particular indictment. There is jurisprudence, of course, that clearly states that a state should not engage in the commission of these crimes. But it allows the national courts and the national jurisdictions to deal with those crimes once they're committed. And I dare say that the reason behind that is to allow instances where an amnesty may prevent further bloodshed. So, yes, the states are not permitted to commit crimes which are considered jus cogens. That's clear. But there is no customary international law in place that would mandate a national court to prosecute such crimes. And there lies the distinction. And I mention this specifically because of the instance in Sierra Leone. Because Sierra Leone had also signed on to the very same instruments that Cambodia has signed on. But nonetheless, a representative of the United Nations, on behalf of the United Nations, signed that agreement. And there is nothing thereafter or during that agreement where you have the United Nations claiming that the Sierra Leone government did not have the authority to enter into such an agreement, an amnesty agreement, that it did not agree with it, that it objected to it, that it would not sign on to it. There's nothing. They signed it, and after there was a postscript. And I mention this and I highlight this because it demonstrates that even for the crimes for which Mr. Ieng Sary is charged, even for these sorts of crimes, national jurisdictions are permitted to grant amnesties, and there is no international prohibition or customary international law prohibiting this. The next point, Your Honors, very briefly, will be on the scope of the actual pardon. And this deals with the language itself, because this was one of the issues. We have three different variations. There are some differences. We used what we believe is the official translation. Now, why do I say official? Because it's the government's official translation. And that's what's posted on the, I believe, the ECCC website. But that's where we received that translation. And then there was, you have another translation by the pretrial chamber, and I believe there is a third translation now. There is some ambiguity and there is some vagueness as to what exactly the drafters meant. I'll cover the text of it, but for right now, let me just focus on this ambiguity. Well, clearly, the only any doubt obviously has to go, we submit, to the benefit of Mr. Ieng Sary. But more importantly, because we have this ambiguity, we submit that the best way, and perhaps the most proper way to resolve it, is to have the parties that were involved in negotiating and actually granting the amnesty give evidence so that there is a clear understanding of what was the intent behind the text. Now, I understand the Prime Minister has since then made public remarks that if you read it very carefully, you'll see I meant something else, or I left the door open. With all due respect to the Prime Minister, his public remarks are political in nature, because that's what politicians do. They make political statements for the benefit of the constituency, which would be the Cambodian people. those remarks have no value in this court, not with respect to this particular agreement. And let me give you but one example, and I do this, and I will try to be as delicate as I possibly can because it is a rather sensitive matter. But the Prime Minister in the past made remarks concerning the international judges that sit on the pretrial chamber. Remarks that they were receiving their instructions from foreign governments. Based on that, we, the Ng Sri defense, then filed a motion for clarification, not for disqualification, but for clarification, because the judges themselves had not publicly denounced or renounced those remarks. And I can only presume because judges, at least in my jurisdiction, normally do not respond to such public remarks. Others may do for them, but it's almost impermissible for a judge to respond to that. The judges clearly made their case. That was the end of the matter. So clearly, what was being stated publicly was incorrect. Now, when you look at the purpose behind the Prime Minister's remarks, it had to do with a particular ruling, which it would appear was to the Prime Minister's dislike. I mentioned that only because when you look at the remarks in this particular instance, obviously it is for political consumption because at this point, his constituency, the Cambodian people, the voters, are the ones that are going to go to the poll. Again, we have the ECCC, it's in existence, so now it is easy to make a remark. And perhaps he may be correct. But if that is the case, I think that the best evidence in this case, the very best evidence, is from the witnesses themselves. And I think that ambiguity can be cleared up in that fashion. Now let's talk a little bit about the substance itself, because there's been some confusion as to what exactly does this amnesty mean. Because, well, on the one hand, we have the pardon. We talked about that yesterday and briefly today. But the amnesty itself makes reference to a 1994 law. A 1994 law. Now, if you read the law by itself, clearly, Article 5 sets it out there, or Article 6, I should say, is very clear that the leadership does not benefit from the amnesty that is provided under the 1994 law. In other words, that law was put into place in order to get everyone but the leadership to put down their arms, rejoin society, if done so within a 6-month grace period, all is forgiven. That was the purpose of the law. So you look at the preamble, it tells you what it covers. You look at Article 5, and then you look at Article 6. And from Article 6, it's very clear that Mr. Ng Sri could not avail himself to the protections or to the amnesty that was granted under the 1994 law. That's clear, and we've never said otherwise. However, and this is what is the most important part of the amnesty that was received by Mr. Ng Sri. It is the however part. However, when you have the amnesty that effectively, when you read it carefully, it is our respectful submission, he's liberated from the constraints covered under Article 6. And then you look to Article 5. And therefore, the amnesty makes an exception that enables him to benefit, to accrue all the benefits that are listed in Article 5. That's our understanding when we look at it. And so when you look at the preamble, Your Honors, and I'm not going to read it because you have it all, but when you look at that, and then when you look at Article 6, and you look at the amnesty, they grant some amnesty of that, we submit that the amnesty allows an exception for Mr. Ingsary to benefit for that in two ways. One, because he's a leader under the leadership, and two, because of the time constraints. There was a 6-month window of opportunity. And obviously, this is 1996. The law was meant for a period within 94, 95. There is one particular case, Your Honor, where it has been mentioned, and references have been made, and I believe even the prosecution has latched onto it as some sort of an indication that of what this amnesty meant and how the law should be interpreted. And that was the case of the Chuk Rin case. I think it's also known as the Backpackers case. But in any event, this individual committed some crimes after the amnesty period, or it might have even been during, and then tried to avail himself of the amnesty. When you look at, under 1994, when you look at the law covers crimes that would have committed during that period. What the law does not say, and I think this is where the trial judge got it wrong, way wrong, the law doesn't say you have 6 months, a 6-month grace period to commit all the crimes that you can and then come in within that 6 months and you will receive amnesty. No. You had 6 months to come in for crimes that were committed during the period, the same temporal period that we're dealing with today. And that's why this case is not instructive at all. It has nothing to do with the amnesty that we're dealing with today. This individual committed some crimes after the 1994 law came into existence, and therefore he could not, under any circumstances, benefit. And to suggest that somehow this case is instructive, I think, is misleading. I believe our submissions, Your Honors, have been rather comprehensive. I've kept my remarks rather short. If there are any questions, I'm happy to answer them, but I believe our position has been consistent throughout, and that is that the amnesty that was provided is a valid one, that those crimes, even if this were an internationalized court, those crimes do not mandate this particular court. It certainly doesn't mandate a national court. Amnesties, states can grant amnesties even for crimes of jus cogens, because the international instruments that they sign on to prohibit them from committing them. But there's no obligation to then prosecute. Of course, we want prosecutions. I don't want to be misquoted on that. Of course, prosecutions are necessary, but also there are allowances, exceptions for amnesties to be provided for all the reasons that amnesties are usually given. Thank you, Your Honors.
The President, thank you, Counsel. It is now appropriate for us to take a 20-minute recess. So we come back at 10:15.
Xong chưa?
All rise.